The agency called it a service fee. You probably assumed that meant something reasonable, a coordinator, some paperwork, a supervisor who checks in. What you may not have calculated is that the fee is not a supplement to your caregiver's pay. It is the structure that determines your caregiver's pay. And in most home care agencies operating in the United States right now, that structure is built to take as much of your hourly rate as possible before any of it reaches the person in your home. The United States Department of Labor launched a dedicated care industry enforcement initiative in 2021. Since its launch, investigators have completed more than 1,600 investigations and found violations in 80% of them. 80%. Not a minority of bad actors, not an outlier cluster in one region, the majority. In southeastern states including Alabama, Florida, Georgia, and North Carolina, that number reached 89%. By the end of this video, you will know specifically how to look up your own agency's compliance history in a federal database that is publicly available and almost never mentioned to families before they sign. The markup model works like this. An agency bills your family somewhere between $28 and $40 per hour for a home health aide. The aide receives between $12 and $20 of that hour. The agency keeps the rest. That is a 40 to 70% markup on every hour, 7 days a week, 52 weeks a year. For a family relying on full-time coverage, annual agency costs run approximately $77,000. The caregiver may be earning closer to $25,000. That math is not an anomaly. It is the product. The franchise model adds another extraction layer on top. The largest home care brands operating in the United States are frequently franchise systems. A franchisee in your city purchases the right to use a national name and operating framework, then builds a business on top of the markup. The franchisor, headquartered somewhere distant from your zip code, collects royalties on revenue. 3 parties take their cut before anything reaches direct care. The family pays the full branded rate. The franchisee keeps the markup. The franchisor takes the royalty. The aide receives what remains, and in most states, no one is required to tell your family how that division was calculated. The failure point arrives when markup pressure meets the staffing shortage it creates. When an agency cannot pay rates that attract qualified caregivers, it fills shifts with whoever is available. The National Employment Law Project, in published analysis of home care employment practices, has documented how agencies routinely classify workers who should legally be employees as independent contractors, stripping those workers of overtime protections, workers' compensation, and unemployment insurance. The misclassification shifts those costs off the agency's books. It does not make them disappear. It places them on the workers. The wage theft evidence is not theoretical. The New York City Comptroller's Office reviewed the top 17 wage theft investigations completed by the New York State Department of Labor between 2020 and 2022. All 17 were home health care agencies. Not one other industry appeared in the top 17. AmeriCare, a New York City home care services agency, settled a wage enforcement case with the New York Attorney General in December of 2025 for a combined $55 million. $45 million in unpaid wages owed to more than 10,000 health aides who worked for the agency between 2014 and 2020, and $10 million to New York's Medicaid program for False Claims Act violations. The New York Attorney General's office described it as the largest wage parity agreement the office has ever secured. The settlement documents show AmeriCare tracked in its own internal records what it owed workers under New York's Wage Parity Act. The company tracked the number. It chose not to pay it. They calculated what they owed. They chose not to pay it. They wrote that down. If you are finding this useful, this is what this channel does. Every video covers something the home care and senior living industry would prefer your family never found out. Subscribing means the next investigation reaches you before you need it rather than after. The deeper you go into the Department of Labor's home care enforcement record, what becomes clear is that the same violations appear in Texas and in New York, in franchise systems, and in private equity-owned platforms. The most common findings: failing to pay overtime, misclassifying workers as independent contractors, failing to meet federal minimum wage requirements. The 80% violation rate did not come from the government targeting only known bad actors. It came from a broadly distributed initiative. 8 out of 10 employers investigated were breaking the law. That is not a compliance problem. That is an industry operating below the legal floor, at scale, for years. The private equity ownership layer accelerates everything. Bright Spring Health Services, headquartered in Louisville, Kentucky, was acquired by KKR, the private equity firm headquartered at Hudson Yards in Manhattan, for $1.3 billion in March of 2019. KKR later listed Bright Spring on the NASDAQ exchange under the ticker symbol BTSG in January of 2024. A BuzzFeed News analysis of inspection records covering 2019 through 2021 found that in the 7 states with the most for-profit facilities, Bright Spring accounted for 40% of serious state citations while operating only 16% of group homes. The state of West Virginia banned Bright Spring from accepting new residents in July of 2020. KKR paid $1.3 billion for the company. West Virginia banned its growth months after the acquisition closed. The part of this that most people miss is not the individual settlement amounts. It is that the enforcement database exists, is publicly searchable by company name, and contains the documented compliance history of the agency your family is considering right now. The industry counts on families not knowing that database exists. The intake coordinator who hands you the contract does not mention it. Almost no one does. Return to the opening number. 80% of care industry employers investigated were violating the law. The agency billing your family $40 an hour has likely never disclosed what percentage of that reaches the caregiver. The family who signed last month did not know to ask. The family before them did not either. Everything before this point is what the agency relies on you never finding out. What follows is what they are genuinely afraid you will do with it. The federal database is the Department of Labor's Wage and Hour Division enforcement database. It is publicly accessible and searchable by company name. Searching your agency takes approximately 3 minutes. First, search the Wage and Hour Division enforcement database by your agency's exact legal name before signing. Allow 3 to 5 minutes, no cost. What it prevents? Committing to an agency with a documented violation history before you have leverage to walk away. Second, ask the agency in writing what percentage of the hourly rate billed to your family goes directly to the caregiver. If they decline to answer, document that refusal. Treat it as the answer. Allow 5 minutes, no cost. What it prevents: paying a 40 to 70% markup with no transparency into what reaches direct care. Third, ask whether caregivers are classified as employees or independent contractors. Employee classification means overtime, workers' compensation, and unemployment protections. Contractor classification signals the misclassification risk that has produced the enforcement actions in this video. Allow 2 minutes, no cost. What it prevents: hiring through an agency whose staffing model carries documented federal liability. Fourth, check whether your state has enacted a home care worker Bill of Rights. New York and California have both done so. Your state's Department of Labor is the correct resource. Allow 15 minutes, no cost. What it prevents: signing a contract without knowing statutory protections that already apply to you. Fifth, research direct hire registries that connect families with independent caregivers, bypassing the agency markup entirely. Verify any directly hired caregiver carries liability coverage, and understand the employment tax obligations that come with direct hire. Allow 1 to 3 hours. Cost varies. What it prevents: paying the full agency markup for the life of a long-term care arrangement. This protocol takes 3 to 4 hours. Annual agency costs for full-time coverage run approximately $77,000. That math is not complicated. Before this video, the home care industry was counting on you to evaluate agencies by brand recognition and intake coordinator warmth. You now know the enforcement database exists. You know what question to ask about caregiver pay and what a refusal to answer means. You know the difference between employee classification and contractor misclassification and what it costs the people caring for your loved one. If you are currently navigating any of this and something in what you just heard matched your situation, share it in the comments, because you are not the only one, and your experience is evidence of how widespread this actually is. The senior living industry spends significant resources making sure families do not find out what you just learned. Subscribing is how you make sure the next piece of information they are hiding reaches your family before it costs them.